We have the incredible privilege to have a good friend of mine and a man who is the founder and chairman of the Liberty Counsel, and his name is Matt Staver. The Liberty Counsel is an international nonprofit litigation, education, and policy organization dedicated to advancing religious liberty, religious freedom, the sanctity of life, and the family since 1989. He does it by providing pro bono assistance and representation on these and related topics. They have offices in Florida, Virginia, and Washington, D.C. And Liberty Counsel has hundreds of affiliate attorneys around the country and also has a presence in the nation of Israel. Matt holds a bachelor, master, and Juris Doctorate degrees, and he also has received, on top of the one he earned, an honorary doctorate of law and a doctorate of divinity. Now, man, I could take one of those honorary doctorate of laws, all right? But anyway, in that doctorate of divinity, but he earned them before. He has argued 2 landmark cases before the United States Supreme Court, and as lead counsel and written numerous briefs to the High Court. Matt has argued in numerous state and federal courts across the country and has over 230 published legal opinions. He is the author of 11 books, most of recent books, Eternal Vigilance, Knowing and Protecting Your Religious Freedom, the most comprehensive book ever written on religious liberty, and The Same-Sex Marriage, Putting Every Household at Risk as well. Mr. Staver produces and hosts Faith and Freedom, a daily radio program, and The Freedom's Call, a 60-second daily radio program. Matt and his wife, Anita, have been married for 32 years. They have 1 daughter, and they have 3 grandchildren. Now listen, Matt Staver obviously can talk to us about a lot of things in the country. I mean, we could all sit here today and interview him and have one of the most compelling 35-minute conversations we've had with anyone. I mean, he understands the courts of America, and he understands not just the Supreme Court, but the courts across the country. Many times when we come to an election season, our attention ends up on simply the Supreme Court, which is huge, and obviously their longevity can influence for 50 years and beyond in American history. So those are important. But do you realize the numbers, and perhaps he can tell you the exact number, but I think it's at least 200 or 300 other judges, etc., that get appointed by every president. So we're talking about deep implications all across the country. And so what we've asked him to do is talk to us about America, talk to us about the court system today and the court systems of the future. What are we facing? So today, it's going to be a compelling moment. And so Matt Staver, we're glad to have you. He's based in Orlando personally. And I want y'all to welcome back to the summit, because he was with us a while ago, probably a decade ago, right at it. Matt, thanks for coming today. Would y'all welcome Matt back here today?
Well, thank you, Pastor Floyd, and all of you. Every time I come back to Northwest Arkansas, I'm so amazed at the growth of this area. And if we didn't live in Orlando, I think this is probably where we would live. But you all are doing amazing things here in this area. Just before I talk a little bit about what I wanted to focus on, Liberty Counsel, in addition to having an international public interest law firm, we also have a program that's called Liberty Relief International that helps our persecuted brothers and sisters in the Middle East, but not exclusively in the Middle East, around the world, who are facing unbelievable persecution of just unimaginable proportions. One picture that comes to my mind is a father holding up his little daughter. She has a little frilly dress on, and he's holding it up above his head, and she has no head. And literally what's happening to people who are Christians, religious minorities, Yazidis, particularly in Iraq, Syria, some other parts of the Middle East, but also in other parts of the world, are just unbelievable. And so we're there to try to help them to have shelter and food and clothing and so forth. Many of those religious minorities, Christians, are not able to go to the UN refugee camps because their lives are not safe there. And that's why there's such a small number of those that are coming here or trying to come here as the Syrian refugees, if you will. Very few. So they have to have their own camps just to survive because they can't go to the UN refugee camps. But pray for those Christians and religious minorities, Yazidis, and others that are literally facing unbelievable persecution. We also have a program called Covenant Journey, and it takes Christian college-age students who have leadership potential to Israel for literally a 10-day life-changing experience. They see all the biblical and historical sites of Israel, have a major spiritual experience in all these different areas. We provide everything. They just pay $500 for those who are accepted as part of the Covenant Journey program that we launched a couple of years ago. And we also bring in modern Israel as well. It's amazing what's happening in this country since 1948. The USB is invented in Israel. Cell phone technology is invented in Israel. The nanography is invented in Israel. You can literally put the Bible on a 1 centimeter square, and that was all invented in Israel. Not sure how you'd read all that, but actually you could with a major magnification device. But cherry tomatoes, I don't know if we had them here, but your cherry tomatoes that you have in your salads, believe it or not, they came from Israel. It's amazing. So it's just an incredible experience for these students. So if you know of a Christian college-age student who has leadership potential, I would encourage you to go to our website, lc.org or covenantjourney.org, because it really is an amazing experience. We have almost 75 colleges around the country that have participated, over 500 students, and we take about 5 trips a year. But what I wanted to talk about is what's happening in the law. As a former dean and someone who worked to found a law school, Liberty University School of Law, and someone who's practiced in all the federal courts all across the country, in the state courts, in the United States Supreme Court. I've argued there a few times, written 30, 40 briefs at the United States Supreme Court. One of the things that's happening in the area of law, the best way to analogize it that I think is a problem, not just in the upcoming election, but beyond that faces everything that we do. We are ultimately seeing the disintegration of the rule of law at all levels. It begins at the United States Supreme Court, and the United States Supreme Court is sort of the big brother, if you will, that sets the agenda, not only for the state Supreme Courts and the other federal judges across the country, but also for law schools, what's taught in law school. They're reading things that are coming from the United States Supreme Court, and whatever philosophy that comes in these particular cases ultimately is what is taught to the next generation. In my case, for example, when I went to law school, I never had to read the Constitution. In seminary, when I was in seminary before law school, I learned Greek and Hebrew, Aramaic and Syriac. I learned history. I learned archaeology, so I could read the text and understand the context of what I was reading to interpret it. I went from that to law school, and in my constitutional law class, we never once had an assignment, never once, to read the Constitution. It was not our first day assignment to read the Constitution. In fact, that's the way it is in law schools across the country, except for just a very few. Liberty University certainly is one that requires you to read the Constitution, but very few. My wife went to a law school in Florida. After class, she came to the professor, and she asked the professor about the 10th Amendment, the amendment regarding states' rights. Whatever we didn't give to the federal government remained the rights of the states. And she asked the professor about certain aspects of that amendment. And the professor looked at her and said, "Why are you reading that? It doesn't mean what it says anyway." It's amazing to have lawyers learn about constitutional law, but never have to read the Constitution. But that's the status of legal education today. And that's why you have people on the bench that say something is constitutional or unconstitutional and has nothing to do with the actual text that we, the people, gave to them. It's like the best analogy I could use is if you are a mathematician and you sit in class one day. You want to learn higher math so you can learn the complicated problems and formulas to help solve problems and so forth. And the math professor now says, now you were taught some years ago, they used to believe that 2 + 2 = 4. But I'm telling you now, it equals 5. And in certain cases, it can actually equal 6. If the foundation of the very basic elements of math are deconstructed, then you can't trust the rest of the system. And I can tell you that what's happening within the legal profession, within the courts, is that the foundation is being deconstructed. Take, for example, some of the cases that I think we would all agree upon that the Supreme Court has done and issued horrible decisions that no one today will support. No one, virtually no one will support. Dred Scott in the 1800s. In that particular case, at the time, Chief Justice Taney, who was a racist judge, on the opposite side of the issue of race than Abraham Lincoln. He issued the Dred Scott decision. And in that case, he says that, Dred, you don't have the same rights as those who are white because you're African American or you're black. And that blacks, he said, are inferior human beings. Our United States Supreme Court has a sentence that says blacks are inferior human beings. Therefore, you don't have the same constitutional rights as those who are of a different skin color, a different race. Now, we fought a civil war over that. Abraham Lincoln resisted that decision. He said that it wasn't the rule of law at all. It was unconstitutional. He advocated people not respect that decision. And sometimes through our history, we've had clashes, disagreements between the different branches of government, between the judiciary or the legislature and the executive. Today, however, we've come to this mentality that whatever 5 people on the United States Supreme Court say, that must be the rule of law. And therefore, the other branches of government must fall into place. If we continue to go down that road and we allow 5 people on the United States Supreme Court to continually impose their will on the people, irrespective of the constitutional text that's in front of them, then we have lost our liberty, we've lost our republic. In fact, Thomas Jefferson said that the seeds that ultimately would give rise to the dissolution of this republic is in the very issue of the federal judges, because they're appointed for life unless they're impeached. And if they're not restrained internally by themselves and they understand their areas of authority, or the other 2 branches of government do not hold them into accountability, it is that particular unelected appointed branch that ultimately could destroy the very fabric of this republic. And I think that's in part what we're seeing with this dissolution of the rule of law. Not only Dred Scott in the 1800s, but another case, 1927, the infamous, if you will, Justice Oliver Wendell Holmes wrote the case called Buck versus Bell. In fact, if you go to the United States Supreme Court today, you'll see a big brown statue. Many people get their picture taken with him. It's the largest statue of any justice anywhere in the Supreme Court building. That building, by the way, was not built until 1935 because the Supreme Court was an insignificant part of our 3 branches of government. It bounced from one house to the Senate basement. It didn't have a permanent place. Many prominent people who were asked to serve on the United States Supreme Court turned it down because it wasn't a prominent position. You're serving in the basement of the House or the Senate. It wasn't until 1935 that we gave it its own building. In that building is Oliver Wendell Holmes. He had, a few years before, in 1927, issued the decision called Buck versus Bell. And he was someone who had a worldview of social Darwinianism regarding evolution, that the human race would evolve and become better and better, that the survival of the fittest and the different races that would ultimately be competing for existence would ultimately mean that the weaker races and weaker people would die out and the stronger people would survive, and we would get better and better. It was something that was quite prominent not just here in the United States, in academia and medicine, academic journals, popular journals, in every area of science and in places around the world. There were certainly dissenting voices. But his dad was a social Darwinist. He taught medical school at Harvard Medical School, and his son, Oliver Wendell Holmes, was a social Darwinist. What does that mean? It means that if evolution is the model and survival of the fittest is the thing, then we are actually harming our existence by giving people medicines to prolong their lives. We should just simply not do that because it would naturally select people out that are not very strong. But more than that, if it is the model, then we can actually participate in it and speed it up. So what they did was they had certain categories of people that were considered the, quote, undesirables. It's not a modern term. It's something that's been around for quite some time. And even a Supreme Court Justice, Ginsburg, has used the word undesirables in the context of abortion. Well, the undesirables back then were people who were low IQ, people who were poor, people who were sexually promiscuous, who had children, for example, out of wedlock back then, someone who had epileptic seizures, and a whole host of other people. Those were the undesirables of the human race, and certain races were the undesirable categories as well. So Carrie Buck's mother had a low IQ. She really didn't have a low IQ. She graduated, or she went through 6th grade. She only had a 6th grade education, but she had a good mind about her. She only had a 6th grade education because the family only allowed her to go to 6th grade. She gave birth to a young child, so she had 2 strikes against her. She had low educational level, although not a low IQ, and she had given birth to a child out of wedlock, so she was promiscuous in that time frame. And so she then was taken and put into a home. And back then, what they did, they wanted to put people into homes and segregate them until they were past childbearing age, and therefore we would get rid of those particular undesirable kinds of people. Well, that was too expensive, so they decided to sterilize them, and so Virginia became the test case, and they put a law there that allowed you to actually take someone forcibly from their home and put them in a place and sterilize them, and the case went to the United States Supreme Court, and Carrie Buck's case ended up before a person who was a social Darwinianist, who really could care less about the constitutional text. He ultimately issued the decision, and in that decision he used the infamous phrase, quote, 3 generations of imbeciles are enough. Meaning, Virginia has put up with 3 generations of your low IQ kind. It's enough. They can forcibly sterilize you to help propagate the betterment of all human society. Well, that case and that decision caught the attention of Adolf Hitler. And Adolf Hitler used that case and that particular law as the model for his eugenics in Nazi Germany. And when the Nazi Germans were put on trial in the Nuremberg trials, they referred to and cited our United States Supreme Court case of Buck versus Bell. You Americans did it. Your United States Supreme Court decision said it. So what's your beef with us Nazis? We just kind of put some of what you were doing on steroids, if you will. We have had infamous times in our courts, particularly at the United States Supreme Courts, where they have been horribly wrong, horribly wrong. So we as the people need to get out of this mentality that whatever 5 people on that high court says is automatically the rule of law. Now, I'm saying that from somebody who argues before the United States Supreme Court. I'm saying it as somebody who was a former dean. I know the implications of that, but I also know that if we don't check what's happening in our court systems, we will lose this republic, because the more they color outside of the lines, as you will, and the more that the other 2 branches of government allow them to do that, then the more that they will color outside of the lines. The Constitution doesn't mean a single thing to them. In fact, one judge in Virginia is so ignorant of the Constitution in the marriage case, a judge that was appointed by our current president. And that particular judge issued a decision that knew it was going to be read by the media. It was on the issue of marriage. She had law clerks. These are law school graduates who are attorneys that are now finished with law school. They're working for her. They're reading the opinion. They're poring over this opinion, and they finally release it to the media with the judge's stamp of approval and with the law clerk's stamp of approval. And in that opinion, she said that we know that the Constitution says all men are created equal. Well, sorry, that's the Declaration of Independence, not the Constitution. But for her, it doesn't really matter a whole lot, because it is whatever she says it is. What we're facing in our country is a cataclysmic deconstruction of law. And ultimately, if we continue to go down this path and have judges or justices at the United States Supreme Court that simply do whatever he or she wants to do, we have lost the rule of law. We, in America, had a unique idea that lex rex, or the law is king, that even the king should be under the law. So if the king violated the law, the king had to be responsible to the law. The law was our king. We didn't have a monarch that could simply do what he or she wanted to do and ignore the rule of law, that we had to have a set of standards that we, the people, brought together as a collective compact, and this is what we wanted to govern ourselves by. Now, if we want to change that, we have the opportunity to. It's the amendment process of the Constitution. It's difficult so that you don't change it all the time, but that's the way to do it. Not 5 justices on the United States Supreme Court. There's other cases that I think some would agree on and certainly others would disagree on, but cases where they've just simply gone off the farm, where they have had horrible decisions that have significant consequences. One of the two cases, in my view, in modern times, are the 1973 case of abortion, suggesting that there is a constitutional right to abortion. You know, wherever you are ideologically on that, there's no way you can stretch the Constitution to say that there is a federal constitutional right to that. And on June 26, 2015, 5 people on the United States Supreme Court issued an opinion that evoked lots of controversy, and including the Chief Justice, John Roberts. I've had a chance to meet with and have dinners at the Supreme Court Historical Society meeting with the justices, and had a chance to sit with the Chief Justice and Thomas and Scalia and many others there. So I know in Roberts' case, he likes collegiality. He doesn't like to have controversy among the judges or the justices. He wants to bring them together. He's not someone who's prone to hyperbole. But when he issued the dissent on June 26, just a little over a year ago, he said 5 lawyers, the first time in the history of the Supreme Court, where someone in the dissenting called the majority lawyers, not judges, not justices, not majority. 5 lawyers, he said, imposed their will, not a legal judgment, not based on the Constitution, and not based on the court's precedent. So if you have 5 lawyers imposing their will, not issuing a legal judgment, not basing it on the Constitution, and not basing it on any court precedent that had ever been written, what is that? It's a lawless decision. That's what he is saying that is happening with those 5, where they literally wrote an opinion that was contrary to millennia of human history with regards to marriage, that now it is no longer the union of a man and a woman, but it is constitutionally between 2 people of the same sex. Now, wherever you are on that, the fact of the matter is the Constitution of the United States of America says nothing with respect to that. And just because 5 people say so doesn't mean it is so. You know, one of the things that's coming up before the U.S. Supreme Court is this case out of Virginia, where Gavin Grimm, who is biologically a female, wants to identify as a male and wants to use the male restroom. The school said no, boys use boys' restrooms and girls use girls' restrooms, and Gavin Grimm filed a lawsuit. The United States Supreme Court just decided to accept that case about a week ago, and sometime in February the argument will take place, and by the end of June we'll have a decision. Now, it could be a 4-4 split, which means that there is no decision, and they could just simply leave it that way. Or they could wait until another justice is appointed and confirmed and re-argue it. We don't know. Or it could be 5-3. We just don't know which way it's going to go. Frankly, I have absolutely no confidence in this court that they will do the right thing. If you look at the actual statute, it's pretty clear. Title IX governs educational institutions, and Title VII governs employment. Both of those have the same non-discrimination provision, that you can't discriminate on the basis of race and sex and so forth. Back then in the 70s and the 60s, when these statutes were written, sex was something very common, in the sense that it was male and female, the common understanding. In fact, Congress has been repeatedly asked to add new words to those non-discrimination categories, sexual orientation and gender identity, and they have repeatedly rejected it. So not only do you have the historical fact of what the statute says and what it was meant back when it was written, but you also have the continuing history that Congress has rejected any attempts to include it as gender identity. Essentially, you think, therefore you are. So it should be an open and shut case, but that's not necessarily the case. We could have a Supreme Court in June of next year that says that, in fact, not only Title IX, but also by implication Title VII, which is your employment and accommodations provision, actually, when it uses that word, it means gender identity as well, which the implications of that are staggering. Take it in the context of a school system. There's a case out in Western Washington, or in Washington State, Evergreen College, where a person, Clay Scott Francis, is biologically male and wants to identify as female. So literally dresses female, but is biologically, anatomically male. So they have one of these policies that is being challenged in this case before the Supreme Court. So Clay Scott Francis goes into, by virtue of this policy, the girls' sauna room and locker room. Is there completely in a state of undress with male genitalia clearly visible. Some college girls go into there unsuspecting. It's just a place where they would go to change, and they get ready to change for their sporting activities. And here's this person completely disrobed with male genitalia visible. So they're shocked, fearful. They go and complain to the school administrators, and the school administrators say that they can't do anything about it, that that person, Clay Scott Francis, can use whatever facility that identifies with that individual. And in this case, says that he identifies as women or female and can therefore use this facility. And they can't do anything about it. So what about the privacy and the security of those girls who ultimately want to enter that particular facility? They don't have a right to complain because this person has a right to do it. Now, in the public school context, the K through 12 context, which is the issue before the United States Supreme Court, it's not just whether someone wants to have the pronoun he or she changed, or Z, which means neither, if you can figure that you're neither male nor female, and you want to be referred to as Z, not he or she, but Z or Zir, Z-I-R, and it goes on and on. It's hard to get your mind wrapped around the abolition of reality that's actually being fueled through the legal system. But in this particular case, it's not just a policy that allows a boy to use the girls' facilities, restrooms, showers, locker rooms, etc., or vice versa. But those policies also apply off campus as well. You can't have a racial non-discrimination policy on campus, and when the students get on the bus for a football game or competition, cheerleading, band, whatever, and they have an overnight stay at a hotel, that now you can discriminate on the basis of race. No. The racial non-discrimination policy applies whether you're on campus or whether you have an off-campus school program. So this policy would apply not only if you're on campus, but if you're off campus. In fact, a school in Maryland said that kind of policy that they're implementing will apply off campus, and boys can use or actually sleep with the girls in the girls' rooms. And you can't, because of privacy concerns, tell those parents in order to protect the privacy of the student. What's happening is literally a deconstruction of law. Obviously, we know that Justice Scalia, who untimely died early this year, his particular seat is up for vacancy. Whoever is the next president of the United States, and whatever that Senate is composed of, will ultimately fill that particular seat. That particular seat, changing it from where Scalia is, Scalia is someone, having known him personally, who really tried to wrestle with the actual text of the Constitution. And if the Constitution didn't say something, then he wouldn't say something. He didn't always get it right. He wasn't perfect. But at least his philosophy as a justice was, it's not his right or duty or responsibility. It's not within his authority to actually write something into the Constitution that's not there. He would wrestle with it, and if we, the people, didn't like it, then we could pass it, a statute, or we can amend the Constitution, but it wasn't his role. So if you replace him with someone that's completely different, you ultimately have these decisions that are 5-4 go completely the opposite. But it's not just Scalia. Justice Thomas, who is a brilliant individual, doesn't question very much while he's on the bench, but he is a brilliant individual and just a gem of a person. He's another person who is in very good health, frankly. And just a few months ago said that he may retire after the presidential election. That's 2 seats. You have 3 other justices that are in or around their 80s. You've got Justice Kennedy, you've got Justice Ginsburg, who has had bad health over the years, and you have Justice Breyer that are approaching or just over the 80 time frame. And any one of those or more than one of those could go. Whoever it is, if one changes or 2 changes, and these are individuals who no longer respect the Constitution, who want to make it up as they go. What ultimately happens is that court system is changed for 3 decades, at least 20 years, if not 40 years, because of their life expectancy on the Supreme Court. And not only that, the judges that I've had the opportunity to argue before on different cases, from Obamacare to everything else in the last 7.5 years, it's not just 1 or 2 or 3 or 4 justices of the United States Supreme Court, as important as that is. Most cases never make it up that high. What ultimately you find happening, that most cases are decided at the Court of Appeals level. And the Court of Appeals have been completely redone in the last 7.5 years. And this particular appointment process that has happened over the last 7.5 years is unlike things that have happened before, whether it's under Bill Clinton or Jimmy Carter or the President Bush, or either Bush, or even Reagan, in that the appointments are more ideologically driven. In some of those cases where these previous presidents have nominated, they're hit and miss. Sometimes they do the right thing, sometimes they do the wrong thing, sometimes their judicial philosophy is to stick with the Constitution, sometimes they're more judicial activists. But I can tell you, every single person that I know, and everyone that I've argued before in the last 7.5 years, at every court of appeal level, has the same philosophy, and that is that the Constitution doesn't mean what it says. That the Constitution is me and whatever I say at this particular given time, because I'm the one, or collectively we're the ones, to actually give it to you, the 320 million Americans. That radically changes our whole system, and it has large ripple effect across our country. So as we're getting ready to approach a new cycle, one of the things that I think that we have to pay more attention to, not just in the election of who might be appointing or who might be confirming those particular justices of the Supreme Court or Federal Court of Appeals or lower court judges, but also beyond that, making sure that our judges, whether they're at the state court of appeal, I know you have judges that are coming up for election here in this cycle here at the Arkansas Supreme Court, or at the very lower federal or lower courts or appellate court level, that those individuals are individuals, irrespective of whether they're Republicans, Democrats, or independents, that they have at least an adherence, a commitment to the fact that they will stay within the parameters of the written text that's in front of them, that they will wrestle with the statute, that they will wrestle with the state and federal constitution. And whether they have a personal opinion that's contrary to that particular case in front of them should be absolutely irrelevant. What should be relevant only is what does the law say about that particular issue. They can write, here's the result. I don't like it, but that's the result. If you, the people, want to change it, then it's up to you. But what they should not do is take it onto themselves to rewrite the Constitution or to ignore the statute by doing that. Because I can tell you what, we can't continue to go down the road and assume that 2 + 2 no longer equals 4. It can equal 5. It can equal 6, or whatever the circumstances may be. In my view, from what I see happening, that's, I think, the biggest issue that we face as a country in terms of bringing this judiciary, among many other issues, obviously, there's lots of them. But that is a huge issue to bring our country back to its proper balance of the separation of powers, to make the judiciary go back to its limited role instead of its superior role. Frankly, I'm tired, and I'm sure all of you are tired, of waiting to that last week of June and trying to figure out what kind of breadcrumb is the 5 people on the Supreme Court going to throw us. Do we have a right that we always knew we had? Or do we have a brand new right that no one ever found before in the Constitution? It's not supposed to be that way. It's not supposed to attract our attention every June. It's not supposed to wake up every morning trying to figure out what did they just do at 10 o'clock the next day. That's a system that's broken, and it's a system that needs to be fixed. We have a few minutes here to have some questions and answers, so I'll just open up a few moments with Pastor Floyd. We've got about 5-6 minutes or so. He asked me if we had a few minutes, if we could just do some Q&A. So if you have some questions, I'll be happy to address them.
Anyone have a question? Yes.
First of all, thank you for edifying us all today. Great talk. Very good. My question is, what is the single most important thing that Congress and the executive branch can do to get that balance of power back in place in your view?
Yeah, I think the single most important thing you could do, there's 2 things. One, impeach. But, the last judge that we impeached was a couple of decades ago down in South Florida, Al C. Hastings. He was impeached because he was a federal judge that was taking a bribe regarding what was going on in his courtroom. We impeached him, and then the people put him into, I guess, a promotion, if you will, I don't know. But he's a member of the U.S. House of Representatives. So, The other thing, and this might be a little bit more, you might want to think, well, this is a radical idea. It's not. Thomas Jefferson believed this, Abraham Lincoln did, Andrew Jackson did. Historically, we've had three different branches of government. The weakest is the judiciary. Now it's become the most powerful, frankly. It's not the way it's supposed to be. But what we have had is the 1789 Sedition Act, which says you can't libel the government. That was passed by the people. Jefferson says that's unconstitutional. I also have an oath to interpret and uphold the Constitution like everyone who passed this law. But I can tell you that's a violation of the First Amendment. And history says he was right. He wouldn't enforce it. What that did is it created a balance. Abraham Lincoln, he got an opinion from the racist Chief Justice Taney on habeas corpus. Let these people go during the Civil War. You don't have a right to hold them. Lincoln wouldn't do it. He sent him another order. Lincoln wouldn't do it. Courts don't have the ability to enforce their own orders. They have to rely upon another branch of government to do it, the executive, namely. In that case, the executive said no, and the court said yes. And who won that battle? Lincoln won that battle. Just because 5 people on the Supreme Court say something doesn't mean that the executive branch or the legislative branch has to just simply fall in line like tin soldiers. Now, you might say, well, that's radical. It's radical for only our current mindset that we have come to, and that is the mindset of whatever 5 people on the Supreme Court say, that now is the rule of law. That's fine if they're really interpreting the Constitution. But the Constitution is the Constitution, and it's not what 5 people just make up as they go. And when they step out of line and go beyond their authority, we need to hold them accountable just like the executive or the legislature. So in that case, I would say impeachment is one, obviously. I would also say Congress has the ability to reduce what goes to some of the courts. They can create bankruptcy courts. They can eliminate bankruptcy courts. So there's a way to eliminate certain kinds of things that they hear or certain kinds of courts. They could break up the Ninth Circuit Court of Appeals, which is the most reversed federal court of appeals in the country in San Francisco. But I think there also is a time where they go so far beyond the constitutional text that one of the branches needs to say, thanks for your opinion, but like Abraham Lincoln, no thanks. And what that causes is a clash of the different branches of government. One branch having a disagreement regarding the interpretation of another. But it ultimately then challenges the real authority of the people. Justice Sandra Day O'Connor, in 1992, everyone thought that they were going to reverse the abortion decision. What happened in 1992 was, after the argument, it was 5-4 to overturn Roe versus Wade, the 73 abortion decision. Medical technology had shredded Roe versus Wade. And it was a 5-4 decision. Rehnquist was writing the opinion to overturn Roe versus Wade. O'Connor and Souter continued to lobby Kennedy for 30 days, from April through May. Change your vote, change your vote, change your vote. Finally, he succumbed to that. He wrote a note to Blackmun, and he was still on the bench. He wrote the 73 opinion. And he met with him May 31, May 30, 1992. He switched his vote. The opinion was taken away from Rehnquist, given to someone else, and it was 5-4 to uphold the Roe versus Wade abortion decision. Now, O'Connor in that opinion says, even if the original decision was wrong, we're not going to decide whether it's wrong or not, but even if it was wrong, we've got to uphold it anyway. Why? She said, because our only authority is in the confidence of the people. We can't make laws like the executives, and we can't, except in limited circumstances, enforce our own laws. We have to rely upon the executive branch to do it. So for our own self-preservation, this is O'Connor, if we back away from the 73 decision, we'll lose confidence in the people because we had such a huge social shift. And now we say we were wrong. And if we lose confidence in the people, we lose our authority. And she's exactly right. It was a decision of self-preservation, in her view, of the court. So we have to come out of the mindset that they're the sacrosanct institution that 5 people can just simply dictate on 320 million Americans what they want, irrespective of the constitutional text, the contract, if you will, with America that we gave them to interpret.
Outstanding job. I have one question for you real quickly. We're wrapping down here.
Okay.
Kim Davis, County Clerk, Kentucky. was asked to issue same-sex license for someone, and she refused. You defended her, and it was obviously a huge case all over the country for religious liberty. My question is, what was your major takeaway from that relating to the future of what's going on in America, in businesses, the way people do their jobs, and all of that? Is there any implications at all?
Yeah, there's a lot. I know we're running here at the end of the time, so I'll just do it really quick. But this whole issue of same-sex marriage that the Supreme Court came out with in June 26, 2015, is going to have huge consequences socially. As a policy matter, frankly, it says that boys don't need fathers. I mean, as a policy matter, that's what we're saying as a nation. You don't need mothers. The implications of that are staggering from a social standpoint. It also is going to and has had a significant collision with religious freedom and freedom of conscience, and that was the case of Kim Davis. It collided with her freedom of religion and freedom of conscience. She simply wanted her name and title and authority removed from the license so that she wouldn't be the issuer of a marriage that conflicted with God's definition of marriage, of one man, one woman. And that's what the simple request was. The court, unfortunately, did not grant that. Could have granted it. Could have been, this case could have been a simple situation to say, okay, we're going to accommodate your religious beliefs. We're going to make some other mechanism. There were mechanisms that we provided. The court did not grant it. It wasn't looking at the religious liberty component of it, and it didn't accommodate it. This case would have had no media. It ended up into this international case where she ended up spending 6 days in jail for her conscience. She would frankly be there for 6 years if she had to be. But ended up where we ultimately won the case at the end, but it took lots of effort all the way to the Supreme Court and the Federal Court of Appeals. It resulted in the election of a new governor, Matt Bevin. And in that case, Matt Bevin was down in the polls. He stood with Kim Davis in marriage. And amazingly, he won, and it was over this issue. And he ended up, first week in office, accommodating her with an executive order because the then governor refused to do so. He did it on the first week in office. Then, interestingly, Republicans and Democrats came together in Kentucky. And they unanimously passed in the House and in the Senate a religious liberty accommodation law. So they all came together and finally worked together when they saw that there was such overwhelming support for the issue of marriage in Kentucky and the consequences of not accommodating religious freedom, that it actually resulted in a person going to jail. So that case is done now, but I think one of the things is that the issue, wherever you are on it, you're going to be confronted with it in your businesses, in your schools. The issues of accreditation of schools is going to take place from every level. Student loans are going to be affected. The use of facilities, churches, and so forth. It's going to have a huge issue that we, the people, are going to have to deal with. And here we have 5 people. And this is 5 people literally are imposing that nationwide as a template without even considering the consequences, because they're not a legislature, of how they're going to deal with this. And so that thing is going to hit and is hitting like a tidal wave, and it'll continue to do so over time. So I think we have to deal with what are we going to do with that, and are we going to ultimately say this is not the kind of system that we want.
Yeah, and your words are amazing, Matt. We really need to bring you back and keep you, man. You're just unbelievable. And you know, the interesting thing about the Kim Davis case is, first of all, Kim stood.
Yeah.
But she stood with gentleness, not what the media portrayed her to be.
Right.
And then she had an attorney who was really good by the name of Matt Staver. And then, listen to this, a politician who was running for governor stood with her, and guess what? We, the people, elected a conservative governor in the state of Kentucky.
Yeah.
I mean, think about that. Sometimes we think, well, we ought to run from that. He didn't run from the trouble.
He didn't run, and it's
He
a
ran to
huge
it.
change since Reconstruction in Kentucky to have a governor like that. And he now is very popular, and he's not afraid of his Christian faith. He's not afraid of standing for values. And he frankly didn't come from a political background. He's a Republican, but he wasn't so much in with the Republican leadership because he had actually challenged Mitch McConnell one time when he tried to run. That's the only time he did it. He didn't win. And then he ran again for governor. And when they realized at the very end, he was going to win or that he had a chance, they started to rally around him. But he was going to stand on principle, and that's what he stood from the very beginning. He's a business person. He wanted to bring some common sense back to government and some responsibility, and he is doing an amazing job.
Matt Staver, thank you for your leadership. You're a real blessing, and thank you for what you do for the country.
Thank you.
This guy's a warrior. Let's give it up for Matt today. God bless you, Matt. Thank you for being here.